We are delighted to welcome you to the first of our four-part webinar series in which we are looking at how you can resolve your construction dispute. Today we will be focusing on adjudication. I would describe this as something of a back to basics webinar series looking at the main dispute resolution options: adjudication today, mediation, arbitration and litigation. The law rarely stands still, and it is always important to keep up to date with the very latest legal and procedural rules, as well as the best strategies and approach for participating in a dispute resolution process. I would encourage you to sign up and join us for the full series, but all of these webinars will be recorded and available on our Vimeo site if you can join us live or would like to listen again or share with colleagues. Just before we begin, to minimise background noise, I've placed you all on mute. If you'd like to ask questions, please do so using the webinar chat function, and we will answer some of these at the end. I'm Ian Drummond, a partner in the Construction and Special Projects team specialising in construction and engineering dispute resolution based in Edinburgh. I'm joined today by Lee, an assistant in my team, and both Lee and I regularly advise on construction contract issues and disputes across a range of projects and clients. We've probably lost count of the number of adjudications we have participated in, acting for referring and responding parties, employers, contractors, subcontractors and consultants, and for adjudicators, all across the full range of dispute issues, project types and contracts. This experience helps to form the basis of our approach and strategic advice for adjudications and informs what we are going to share with you today.
Thanks, Ian. We will start today with a brief review and reminder of the background, history and the statutory basis of adjudication, and provide an overview of the adjudication process. Some of you may have participated in a number of adjudications, but it is important context to remember the background to the adjudication process, as this has an impact when we look at the case law developments and how the courts approach adjudication. We will then share some of our strategic advice for those participating in adjudications by going through the life cycle of an adjudication. Some of our tips will be relevant for both sides of the adjudication you are on, and others will be specific for one side or the other. Knowing the likely strategies of the other side can of course in itself be useful. We will conclude with some recent important case law developments which need to be considered by those participating in adjudications and which may have a bearing on the strategies to be adopted. Adjudication disputes are becoming a recurring theme in the English courts, which are highly persuasive in Scotland, and we therefore benefit from a regular update on the court's approach to adjudication. The construction industry historically suffered from a high number of disputes and an adversarial approach to business. The traditional court system was not really set up to assist with resolving disputes mid-project, and court or arbitration proceedings were causing industry-wide problems such as contractor cash flow issues. In his 1994 report, Constructing the Team, Sir Michael Latham recommended that adjudication should be the primary dispute resolution forum for the construction industry. The primary intention was to have a quick and cheap process which could be used to resolve disputes at the point when they arose during projects. It was always accepted that such an approach should be fairly rough, but at that stage it was envisaged that a person of skill, such as a QS or engineer, would be appointed to investigate the disputed matters, which would be relevant to his or her area of skill, and to determine matters in a quick but informal way, allowing projects to keep progressing. Lawyers, whilst not excluded, were not really envisaged as part of the process, but a right to later recourse through arbitration or the courts was provided for. So the quick, rough justice of adjudication would allow a temporary decision to be made, which would not interrupt the delivery of projects, and any remaining disputes thereafter could be dealt with in the more traditional way, usually after the project concludes.
It is commonly thought that the success of adjudication has resulted in a move away from what was originally envisaged. Adjudication was seen as being very successful in comparison to the alternatives of arbitration or court, which led to more complex and higher value claims being referred to adjudication. However, as more was put at stake in adjudication, parties needed to have increased legal and expert involvement, giving rise to much more complex adjudications and higher costs, and consequently the expectations on adjudicators and of the quality of their decision-making grew, particularly as adjudications would frequently touch upon numerous technical and legal issues with high stakes and high expectations, meaning that parties would be more willing to test adjudicators' decisions at enforcement stage and to exploit any loopholes, which would often result in significant judicial scrutiny. And this in turn has driven up the quality of adjudicators, arguably moving away from the simple person of skill envisaged. So the upshot of this evolution is that, firstly, adjudication is now close to a formal judicial process involving the adjudicator judging between the case put forward by either side, rather than investigating the law and facts for him or herself and making a decision based on his own experience. Secondly, the involvement of lawyers and experts is normal. Thirdly, the process is more costly and each party's costs are not recoverable. Fourthly, the general quality of adjudicators across the board has increased, but adjudicator fees and fee rates have similarly increased. Fifthly, we now have greater certainty as to the boundaries of the process and what is expected of the adjudicator and the adjudicating parties. And sixthly, generally speaking, it is a process that works and continues to be used on a regular basis for high-value, complex and strategically important disputes. And finally, surprisingly, the incidence of fresh proceedings being raised in court or at arbitration following adjudication remains proportionately low.
The basis for adjudication is statutory. The Housing Grants, Construction and Regeneration Act 1996 as amended. This Act provides that any party to a dispute arising from a construction contract has the right to refer the dispute to adjudication. Dispute means any difference between the party and construction contract is defined by reference to agreements for a wide range of construction operations, with a number of clear exceptions. The exceptions include drilling and extraction of minerals or oils and power generation works. The courts have generally tried to define these exclusions narrowly. For example, in the case of Laker Vent Engineering Limited versus Jacobs, the dispute involved a heat and power plant being built ancillary to a paper-making factory. The court did not entertain a jurisdictional challenge based on the power generation exclusion, as the heat and power plant was a small component in a much larger site, and accordingly the statutory right to adjudication was upheld. Similarly, there is an exception for domestic housing constructions, but the courts have interpreted this exception narrowly, so it does not apply to housing constructions which have any commercial element to them, even when the main purpose is domestic residence. This was the case in Westfield Construction Limited versus Clive Lewis, where Mr. Lewis failed to persuade the judge that he intended to occupy the property as a domestic house after the construction works, and so this exception simply did not engage. Underpinning the statutory right to adjudication is a regulatory scheme for construction contracts, which includes more detailed provisions for the adjudication process. Parties are free to make their own contractual provisions about adjudication, but there are strict rules in the Construction Act which, if not followed, will result in the scheme applying by default. There are different schemes north and south of the border, but the differences are not usually material. Adjudication commences when a referring party provides the other party with a notice of adjudication. Unless there is any contractually named adjudicator or agreement can be reached, they will then seek a nomination of an adjudicator from a nominating body, such as the Institution of Civil Engineers or the Royal Institute of Chartered Surveyors. A more detailed referral notice with any supporting documentation is provided within 7 days of the notice, which is then responded to. Both sides usually have one further chance each to respond, and then there may be a hearing or meeting. The procedure thereafter is flexible, and the adjudicator can determine the timetable and the written and verbal submissions that will be accepted. The adjudicator usually has 28 days to reach a decision. This can be extended by 14 days if the referring party agrees, or a longer period if both parties are in agreement.
So now let's look at some of the important strategic and practical approaches to adjudications. We'll do this by running through the adjudication process and considering the approach to be taken by either or both parties at each stage. We'll start before adjudication proceedings is even raised. Adjudication should always be part of an overall strategy, more of a means to an end rather than the end itself. This is because adjudication is at its most effective when dealing with issues in bite-sized chunks. This makes each adjudication less expensive and more focused. For example, deal with extension of time first, then loss and expense, and then the final account. Or get a determination of responsibility for late instructions and or design deficiencies first, and then claim for the money separately. Often, at some point, a settlement can be reached as each party's position becomes clearer without there needing to be an overall adjudication decision on everything. As referring party, you have the advantage of choosing when to launch the adjudication proceedings, so you should use this advantage and carefully choose when to raise the proceedings against the context of other ongoing discussions, or other considerations such as the respondent's upcoming financial year end. But also, do wait till your case is fully ready. Don't issue an initial notice of adjudication until the full referral notice and production documents are ready or almost ready. Also, do wait until all the key members of your team are available. Don't launch proceedings just as everyone is about to go on holiday or when they are engaged in an urgent tender or a critical time-demanding project or other task. As respondent, whilst the timing is less within your control, if you think an adjudication is about to be launched and the timing will be bad for you, then do try to stall matters by, for example, undertaking further discussions with the other party. In the meantime, do undertake all preparations in anticipation of the adjudication, and don't wait until you receive the notice of adjudication or indeed the referral notice before doing this. Likewise, do make sure that your key team members can be available as necessary. As a referring party, although this can apply to the respondent too, do also think about getting an independent expert's opinion before launching the adjudication, especially if the claim involves extension of time, measurement, or legal issues. The adjudicator is likely to be more impressed with a supportive independent expert report than he will be with a claim presented purely by the referring party or through a claims consultant, especially if there is no independent expert presented by the other side. But the important point in all of this is to prepare fully if you can, as the adjudication process is very quick, and taking any time available to prepare before the process starts is hugely beneficial.
Once the adjudicator is agreed or appointed, there are a number of practical considerations that you may need to engage them with. As respondent, if the adjudication is launched at a time when key team members are on holiday or otherwise unavailable, do raise this with the adjudicator at the earliest opportunity and gain the necessary time to allow for this. Adjudicators are much more inclined to be reasonable and flexible nowadays with regards to timetables. In relation to the adjudication timetable to be fixed by the adjudicator, do be reasonable. If an extended period is sought by the other side on a reasonable basis, don't just object to that for the sake of it. Only object to it if a reasonable basis for doing so exists, because within a short space of time, the boot is likely to be on the other foot. On the other hand, if there is a reasonable basis for objection, even if you may not be inclined to object at first, you may wish to do so if only to lay down a tactical marker that you will take a robust approach. As referring party, if a problem with the notice of adjudication or referral notice has become apparent, for example, there are errors in parties' names or with the means of service of the papers, or there are other potential defects in the procedure or the adjudicator's appointment, do seriously consider reserving the notice. These are issues that are likely to undermine the jurisdiction of the adjudicator, that is, his or her ability to determine the dispute and produce an enforceable decision. On most occasions, the only loss for restarting the process will be the nominating body application fee and the loss of a couple of weeks' time maximum. But compare that with the cost of jurisdictional issues being raised or the potential for the adjudicator's decision ultimately being unenforceable in the court. As respondent, if potential jurisdictional issues are identified, do consider carefully whether these arguments should be raised, or at a pragmatic level, do the merits of the claim need to be resolved one way or the other anyway? If jurisdictional challenges are to be made, do reserve those jurisdictional arguments carefully within your written adjudication submissions or written communications with the adjudicator, so that these can be raised again at enforcement stage if necessary in court. We are certainly seeing an increasing nervousness amongst adjudicators when it comes to jurisdictional challenges, with adjudicators sometimes upholding a challenge and resigning, rather than continuing on a potentially challengeable basis. This is in part because, on current case law, if adjudicators produce an unenforceable decision due to jurisdictional problems, then they may not be entitled to their fees. This was the issue considered in the case of Stork Technical Services, RBG Limited, against Marion Houghton Ross, executor of the late George Ross, a case which we acted in. As a respondent, if you are seeking more time to investigate matters or to build your defence, or tactically to land a blow on your opponent with a view to enhancing your settlement negotiating position, jurisdictional challenges can be effective. The areas for investigation are usually around contractual notification requirements for the notice of adjudication, the adjudication appointment process and timing, whether the matter raised in the adjudication notice area is fully in dispute yet, and whether there is more than one dispute referred, and whether the project concerned falls within one of the exceptions to the adjudication regime. However, do not make spurious challenges, as this will likely frustrate the adjudicator and responding party, and your challenge will likely be unsuccessful.
As the adjudication process is largely a paper-based process, good preparation and management of documents is vital. The referring party should spend time carefully setting out the background to matters and the issues in dispute and, importantly, carefully focus the questions or issues that you are asking the adjudicator to determine. So, 1. Make sure you seek specific orders. 2. Within these specific orders, allow the adjudicator room for manoeuvre. And 3. Remember that the orders sought can be declaratory and don't need to be restricted to seeking awards of money, time, etc. As referring party, do also submit signed witness statements supporting critical factual matters, because adjudication is akin to a judicial process, and the referring party has the onus of proving its claim and the facts on which that claim is based. Be careful with the wording in these statements. They can be edited, but they should sound like the words of the witness, not the lawyer or statement drafter. Witness statements can, of course, be similarly useful to the respondent. Do support the factual statements that you make in your referral notice and response with vouching and relevant productions. Don't presume that in the absence of that vouching, the adjudicator will take a view in your favour. Both parties should ensure that they submit all vouching and backup. Don't presume that summaries will suffice. Some adjudicators may accept summary material, but many will not. And also make sure that the written submission which accompanies these documents clearly references the productions so that the adjudicator can easily find them and look at them when examining your text. Just because some key evidence is in the papers doesn't mean an adjudicator will find it and rely on it. Last year's case of Broughton Brickworks against F. Parkinson is a case in point. There, a vital email, which the adjudicator later admitted would have changed his decision, was not used by him to come to his decision because it was buried in the productions, and the references to it within the written submission were incorrect. The courts had little sympathy with the party complaining and enforced the adjudicator's decision despite this. And in doing so, the court stated that the onus is with the parties to ensure that relevant evidence is clearly and carefully presented to the adjudicator.
There are a number of more general strategic points to make about the written submission stages. As respondent, do put in all possible lines of defence into your response to the referral, including potential counterclaims and set-offs. In general, don't hold back information or arguments for later in the adjudication process. Usually this is not a good strategy. Also, any arguments not raised in defence in the adjudication will not be able to be raised at enforcement stage. As respondent, in the response, do focus your arguments on the key points unless you're weak on these. If you consider that you are weak, then throw as much mud as you can in the hope that some of it sticks. If you take the approach of only focusing on the key points and arguments and not responding to immaterial points, then make this clear in your response. Don't introduce new points and arguments unless you have to, and if you do, then the claiming party will get a chance to respond to these new points. If at any stage either party realises that their position is weaker than initially thought, do consider carefully whether it is worth seeing through the adjudication process, or whether it would be better to negotiate a resolution in order to mitigate risk prior to the adjudicator reaching a decision. An adjudicator has the power to allocate his fees, so if you lose an adjudication, you are likely to have to pay the full fees of the adjudicator, which can be many thousands of pounds in a complex adjudication.
We usually advise clients to try to seek a hearing or meeting in adjudications, although having one is ultimately at the adjudicator's discretion. An adjudicator may not appreciate the full colour of the dispute just by reading the written submissions and witness statements. If you have credible and impressive witnesses, this is much more easily demonstrated in a hearing than through a written statement. Also, a hearing can be used to ensure that the adjudicator has picked up on and is considering all of the key legal and factual points. it is too late if you receive a decision in which the adjudicator has clearly missed the point of one of your defences. In a hearing, you can observe what he or she appear to understand and what they don't, so that you can clarify any points at that hearing as appears necessary. Do make sure that prior to the hearing, the adjudicator produces an agenda and requires parties to confirm their attendees so that there are no surprises on the day. If one side proposes an excessive number of attendees, then do apply to the adjudicator to get these restricted. You should always prepare well for the hearing. What you should do firstly is discuss and plan carefully who should attend. If the possible attendees are not robust individuals, then consider not having them attend, although you should weigh up against this the danger of the adjudicator taking an adverse inference from their non-appearance. Secondly, consider carefully the agenda topics and decide who will speak to these and plan for the likely points and questions that will come up and how those will be answered. Thirdly, avoid all attendees gathering at the hearing for the first time together. Try to meet beforehand to go through the issues and to explain the process of the hearing to the witnesses. For example, questions should be answered truthfully, answers are not to be embellished, those answering questions should try to keep eye contact with the adjudicator and to speak clearly, and so on. And finally, at the hearing, be allowed to opportunities for the other side's case to be harmed by their presentation at the hearing. For example, if their individuals are sympathetic to your case or are not robust, or if you want to get them to repeat a weak argument that can be easily attacked, in order to create an impression with the adjudicator that favours your case. A hearing also sometimes gives you an opportunity to cross-examine witnesses if you think that is necessary and justified, but you'll need to be prepared to articulate a strong justification for doing that, because you will meet resistance from both the other side and the adjudicator. Also, you should consider having separate hearings for separate issues. For example, if there are legal issues to debate, avoid having everyone from either side attend that hearing. Also, through the adjudicator, you should challenge statements that are made by the other side that you consider are not true and which are, for example, contradicted by documentary evidence. And, at the close of the hearing, you should make submissions to the adjudicator on issues of credibility and reliability of the witness evidence, if that is in question. This is because adjudications often come down to witness evidence on the factual matters, and the reliability and credibility of witnesses can be critical to these points. Do consider conceding points during adjudications if they are of less materiality and are beyond rescue. You may find that this underlines the credibility of your own case. At the hearing, if issues arise which cannot be answered there and then do request the opportunity to cover these in a further written submission later on, whilst allowing for the likelihood that the other side will have a chance to respond. And then finally, once a decision is issued, firstly, read the decision carefully and inform the adjudicator within at least 48 hours of any slips and seek corrections of these. Then, as a respondent, if you lose, then do seek to either negotiate a better result or consider taking your chances at enforcement stage in court.
To finish our webinar today, we'll now take a look at 3 important recent case law developments and consider what impact they have on the adjudication process and strategy. The first case is one that many of you will be familiar with, and which we mentioned in our top 5 adjudication cases of 2014 webinar earlier this year. That is the case of Eurocom Limited versus Siemens plc. When applying to an adjudicator nominating body, Eurocom's agent made what amounted to a fraudulent misrepresentation in the nomination application form. They had noted a number of adjudicators who would have a conflict of interest, where no actual conflict of interest exists. The intention was to steer the nominating body towards a desired adjudicator of Eurocom's choice. The court ultimately held that the nomination, and therefore the adjudicator's decision, was invalidated by the fraudulent misrepresentation. We have often seen such approaches being used to try and engineer a desired adjudicator, but after this case, such approaches are simply not worth trying. Any advantage in getting your desired adjudicator is outweighed by the possibility of their decision being unenforceable. We would certainly recommend that thought is given to the nominating body being used. Details of those on each nominating body's list can often be obtained, which can be helpfully used to definitely exclude an adjudicator when a client does not want them, or to assist with getting an adjudicator of a type closely suited to the dispute in hand. For example, you will more likely get an experienced engineer as adjudicator in a very technical engineering dispute by applying to the Institution of Civil Engineers. The next case is Mr. Justice Coulson's decision in Caledonian Modular Limited versus Mar City Developments Limited, which will have repercussions for court enforcement. Adjudication decisions are temporarily binding, and the courts will usually uphold an adjudicator's decision in any enforcement application, barring a proper jurisdictional challenge and regardless of apparent merit, until the substance of the dispute is otherwise decided in arbitration or other court proceedings. In the Caledonian case, Caledonian, the contractor, had been awarded a £1.5 million payment by an adjudicator because of the lack of a payment notice or intention to pay less notice by Mar City. This award was made on a technicality. The adjudicator did not examine the merits of Caledonian's application. Mar City refused to pay as they considered that there was little basis for the award on the merits, and Caledonian asked the court to enforce the decision. The court decided that where the merits and substance of the dispute boil down to a short and self-contained point, which can be readily ascertained in a simple hearing and doesn't require oral evidence, then the defendant is entitled to have that point heard as part of the enforcement proceedings. In the circumstances, the point was the adequacy of the labelling of the payment application upon which the adjudicator's decision rested, and as Mar City won the point that the payment application was insufficiently labelled as such, the adjudicator's decision was overturned and the enforcement action rebuffed in one single hearing. This is likely to be a rare example, as the court will not want to undermine the critical binding nature of the adjudication decision, but will nevertheless likely be a tactic employed when defending enforcement proceedings. The final case to update you on is about prescription and limitation, and the decision of Aspect Contracts Asbestos Limited versus Higgins Construction. This is a Supreme Court decision which decided that, firstly, there is an implied right as a consequence of the scheme that a party paying a sum found due in adjudication can seek recovery of an overpayment once there's been a final determination by a court. Secondly, that paying party will have 6 years, which is the English limitation period, from the date of payment in which to raise proceedings for final determination. But, thirdly, the receiving party will only have 6 years from the original date of the cause of action to raise proceedings for final determination if they wish judicial confirmation of an adjudicator's award or are seeking an increase in the sum. That ruling allowed Aspect to challenge the sums they were due to pay Higgins, but denied Higgins the opportunity to counterclaim or to succeed in arguing for a higher sum payable, as the original claim was beyond the limitation period. This decision is likely to be persuasive in the Scottish courts. Our primary advice following this case is that parties should set out an agreed approach to when adjudication decisions will become binding in the contractual dispute provisions. Such a provision could allow for an equal period after an adjudicator's decision for challenge on either side, and will allow finality of an adjudication decision after the set period of time. Where such provisions are not in place, even a winning party must now consider carefully whether court proceedings are going to be necessary to protect the adjudication outcome and the timings of those proceedings. Our team regularly produce update articles about relevant and interesting construction cases and updates, covering the types of updates we have discussed today. If you don't already receive our updates, then please let one of us know and we can ensure that you will receive them in future.
We've now come to the end of the presentation, which we hope has been useful and interesting. I will take the opportunity to remind you that we have the 3 remaining webinars of this series coming up in October, November and December. We are also hosting 2 autumn evening seminars in October, which are replacing our traditional autumn breakfast seminars, and full details of these can be found on the link shown on screen. I would encourage as many of you as possible to attend and take advantage of the interactive nature and the networking opportunities presented by our new evening seminar format. I do hope that you've enjoyed this webinar and found it informative and useful, and we look forward to welcoming you to future webinars and to our evening seminar if you can make it along. Thank you very much.
Thank you.